Hi, good afternoon. Today is September 5th, 2025. It's 2:28 p.m. My name is Reynaldo J. Ayamarcano, and I'm recording this video at my home located at the 26714 Valley Side Drive, Katy, Texas, 77494. So this is the second part of this session. And so for this second part, I have a few topics, okay? I'm not going to redo the introduction to the segment because I already did it in the previous segment, but we're talking more about legal topics and things like that. Okay. But before we get into those topics, I have a couple of small things. My system picked up, and this could be a thing, I don't know, but picked up that Maria Alejandra, so the agent that let's say infiltrated my social circle since 2014-15, that lives in the street nearby and is married to Angel Vargas da Costa. She went to the Simón Bolívar University in Caracas, the same university that I went to. And my systems picked up that she attended university probably the same years as one of the co-founders of Smartmatic, the election automation company, who the co-founders are Venezuelan. Of course, because they needed to export the technology, right? So she went to university at the same time as him, to the same university, one of the co-founders. And this is interesting because specifically the university, right? So I'm not going to spend much time here, but just to say this university was special. It was an experimental university. It was free, but it only had capacity. When I went to that university that year, the admission pool was only 900 seats for the entire country. Okay, it's really hard to get in. And they went to that university a few years before me. They're older than me by a few years. Like they're basically in the age range of the PayPal mafia, Maria Alejandra and the co-founder of Smartmatic. So they're a bit older than me. So they went to that university a bit. They started a bit before, right? Like I imagine a year 89 or something like that. I have to check the data, but it's around that time. Now, this is interesting because this university was experimental and it started accepting students, like it opened for business, I think, sometime in the mid 80s. Right? So it's an institution that hadn't had a long history, right? And the admission pool was very small, especially in the very first few years of its functioning. What I'm trying to say is that the probability that they know each other is very, very high because of all these factors combined. Okay, so this might be relevant. Maybe that's why Maria Alejandra is Maria Alejandra. Right? Okay, so now this is something I've been meaning to say. So this is one of the physiotherapy companies that Marjorie Broussard referred me to. It's called Select Physiotherapy, and their office is basically in the. I don't have this doesn't have the actual. Yeah, but they have I mean, this is a national company, right? But the one here in Katy, at least, is heavily marked in the index of Elon Musk, the Geo Index, and it's in this place that I call. It's like a Bizarro city hall that they have next to La Centerra, right? Like they have this area heavily protected, buffered, heavily marked in the index, where they have all their small businesses are there. Right? So check it out. Okay, so now let's talk about a bit about software engineering and about legal topics. Okay, but with a twist of software engineering. So I'm going to start by describing the problem I was trying to solve with this. Okay, so the problem is that, well, obviously, in the recent sessions, we've talked about how they use specific professional circles, among them lawyers, right, and law enforcement, as weapons against 98% of the population, right, to harass them, to get them out of the way, to create trouble for them, right, systematically at a scale, planet scale. So obviously, me being restricted, let's call it that way, in this area of Texas, where they have, thousands and thousands of families, right? They control all of that professional circle. So for my legal needs, I cannot go to a lawyer, obviously, right? Which makes sense, because they put me in the nuclear program in 2014, 15. So the problem I was trying to solve is, how do I get access to, a fair chance in court when I don't have access to a lawyer, and I'm not a lawyer. And yes, I can figure out stuff and apply logic, but at the end, right, I don't have legal training. And they're weaponizing the legal system in this very moment against me, right? Like, Morgan Heibner sent me like 3 emails this morning citing things and, and citing articles and regulations, and she's misciting them, like misquoting them, right? Like, it's funny because, so she's deliberately lying on her emails to trying to trick me to withdraw exhibits that are damning to them, right? But that's what they do, right? They weaponize the lawyers. So this was a problem that I realized I had months ago, right? I mean, it was an obvious problem to me. And the question, of course, is, okay, so how do I overcome this challenge? How do I win this with the resources I have? Was the question. I'm just walking you through my thought process, right? And I realized that, I mean, I thought about this long and hard for many months, right? For months. And I realized that the only possible solution I could see was to try to drive this to my court, to my area, where I am the strong player. In the legal field, they are the strong player, at least here, because they control the circle. Right? I can't. There's no place I can go to, or nobody I can talk to in the legal circle in Katy that they do not control. So the solution is, well, I have to break that cycle, and I have to bring the battle to my court. And so that, obviously makes me question myself, what is my strength? My core strength is software engineering and data science. So that's when I realized that I had to develop a system to fight the legal battle. And I've been working on that problem for a long time, right? And I have a systematic solution to the problem, which I call the KOL legal vaccine. Of course, I'm not going to give the technology in this session. I'll offer it. I'll open source it. I'll give it to the FBI, but I won't give it to them in these conditions because they will use it against me. But I'll describe the idea, okay? So the idea is to use data science and software engineering processes or principles and software development principles to be able to counteract their legal attacks. Which, if you think about it, is the same thing that I did when I was fighting with them for the positions in Google search results. I implemented a systematic data-driven solution to fight them, and I won the battle, right? To the point that then they incapacitated me physically, so I could not keep fighting. That's what they do. When they lose, then they go nuclear, right? They use violence. When they don't, when they can win, they use violence. Um, so, so that's what I've been working on, right? And if you see my filings in the court, you will see the evolution in this, right? You will see that my filings over time had become more and more sophisticated. It's not because I became smarter or because I gained legal training. It's because my system became better as any data science based system. As time passes and you get more data, the system improves, right? So that's why the feelings get more and more sophisticated. And I'm going to talk about that because I think this is more a technical session, right? This makes no difference in the conflict, I think, but it's interesting. It's an interesting development, right? That I developed this. So I'll explain the idea. Okay, so the idea is, if you, I mean, I'm going to say things here. Remember, I'm not a lawyer, right? So I'm just an engineer throwing logic at a problem. Okay, I may say things in respect to the legal profession or the legal practices that may not be accurate. Okay, and please forgive me if I make those mistakes because I'm not a lawyer. Okay, I'm just a small guy trying to survive. Right? So, but from what I gather, right, from the years of attacks that they've performed against me, and the motions that they file, and all those things, you can typify, I would say, right? You could put into categories, into buckets, the type of things that they do, right? Whether it's like, hiding the true intention of emotion, like what Morgan Heibner did recently, right? So she filed that motion a month ago for a supposed psychiatric evaluation. And the motion, you read it, and it's all focused about psychiatric evaluation, right? It's focused on that. But in the title, she hid and temporary orders, right? So yesterday, less than 24 business hours, so less than a day, a working day from the actual hearing, she fires and submits a list of things that she was going to address in the motion that had nothing to do with psychiatric evaluation, right? They have to do with things like conservatorship of property, division of property, child custody, like all these complex issues, right? That are not explicitly mentioned in much detail in that order. The order seems to be about psychiatric evaluation request, but then at the last minute she fires all this, right? It's a tactic. It's a legal harassment tactic. Of course, that is an improper notice because the notice that she's giving me yesterday, she's giving me only 24 hours to prepare for that thing that she's sending that would take me a month to prepare for, right? So she's abusing the legal system and the procedures to harass me with legal processes that are unfair by design. So things like that. But discounting that, right? When you get into an argument about a legal issue, it usually comes down to one party arguing the application of a law or a rule or a procedural code, right? That there's certain categories of things that you can do, and the other party arguing another set of rules or invalidating the argument of the other party, saying that the rule doesn't apply for X, Y, or Z. Okay, so that is more or less the dynamic, right? That's how these legal arguments and debates. And by the way, one thing I have to say, after developing this system, I can see clearly, right, why they picked this profession, right, to control the world, because it's a profession that is in a way mystified, like the way the law is written, the way the legal instruments work, the way the court functions, it's all a bit cryptic. It's not accessible to a pro se litigant, to a guy trying to get justice, right? You have to go through a lawyer. And because they control the lawyers, they are at an unfair advantage against the other 98% of the population. So in reality, the only ones that have lawyers is them, because everybody else has to hire their lawyers. And how are you going to win in that situation, right? This is what happened to me with Mark Zurich in 2021, right? I thought he was representing my own interest, and when I refused to sign the non-disclosure agreement he put in front of me, he threatened to sue me as my lawyer. Imagine that. Your own lawyer threatening you to sue you. Please. Anyhow, so I guess what I'm trying to say with that comment is that it's one thing that is needed to fix society is to democratize the access to justice. And the only way to really do that is to lower the barrier of entry to the legal system for the pro se litigant. You should be able to get access to justice without paying anybody. Think about it. It's a basic right to be heard in court, to have your day in court. Why are you indirectly being forced, channeled into a system in which your only option really is to hire a lawyer? So much so that this is something I want to say. I want to say this later. Why, right? But I'm looking for a place to do. I mean, I found a few, right? But a place to do a recorded deposition of the petitioner, of my former partner, right? I want to get her in a room and depose her. Because imagine, right? Like, you saw the legal mistake she made in that 9-minute video in front of the call mobile. Imagine what I will be able to get if I get her for 4 hours in front of a court reporter and a video camera, right? I'm going to get a level of legal ammunition that is going to spill outside of this, right? And remember, we have that other case in the federal court in October, I think, right? So that, I mean, and now because they're doing all of this, I have the right to depose her because she wants to have me committed into a mental institution. I have the right to depose her, and she's using, and Morgan Heidner is using the legal processes to harass me, right? Now, and she said in front of the camera that it was a legal tactic. So now I have the right to ask for a deposition. Imagine that. Imagine in the ways this could backfire for people like Wilmer Ruperi, who is named in the other lawsuit. Now, what I was saying is that it should be possible for anybody to get access to justice. This thing they have going on, at least here in Katy with the lawyers, is the equivalent to the 3% racket. I mean, you cannot get access to the thing without going through them. And of course, they use that as a weapon, right? But this is possible because the way the legal system works. And I'm telling you this based on my own experience going through this process of being a pro se litigant, right? It's a steep barrier of entry that not everybody would be able to overcome. So this is another reason why I created this framework that I'm describing, the KOL legal vaccine. So the idea is that I applied software engineering and data science principles and technology to solve this problem, okay? I'm not going to go into the details of the technology, but I'm going to give you an example of how it works, okay? So let's start with this example, right? So, you know, we had that hearing on Monday. We was according to the motion. You read the motion, and 99.5% of what it talks about is the psychiatric evaluation. But then Morgan Heidner, last night, sent that, I don't know how you call that, but like that, that long list of items that she supposedly wants to talk about, right? That were not mentioned with that detail. It only said temporary orders. Anyhow, right. So before she said, I mean, she waited until I filed the motion to send me that. Right? That's part of the trap, because if she had sent me that before, I would have addressed it in my motion. So she waited until I filed first. Right? Okay, but that's fine. So I was working on my motion of opposition, right, to their request. Right? And of course, I know that my former partner was recorded in front of a camera saying that the request for a psychiatric evaluation is not out of real concern, but it's a litigation tactic to get leverage to coerce me into a settlement. So I know, right, that I got them, right? So, well, I created my reply, my answer, right, in opposition, my response in opposition, and I have a framework that basically allows me to do, because as I said at the beginning, right, like all these dynamics that happen in court, or at least in this motion, from what I gathered from my small experience in this, right, like I'm sure there are areas that I haven't even thought about, right, but for my needs, this works, right? So because this is so repetitive, and there have been so many cases in the, in the record, in litigation, in history, because people have the same problems, right? Like it's the same types of issues, right? So there's records and precedents for everything that you can think of. So what I did was that I created a way to systematic evaluate a legal document, right? So you can ask my system things like, so what I did, right? So I created my response, like a draft, okay? And I run it through the system, and I configure the system to tell me if it's, a sound argument, okay? And it passes the checks. After it passes the checks, I label that draft a canary. A canary in software development is an artifact of your software that you've built that you think you can deploy in production, but you're not sure, right? So what you do is that you test it first. You test it in a control environment to see how it behaves. And the reference comes from the thing of the canary on the mine, right? Like back when people were mining in mines, like physically getting coal out of mines, the first thing they would do is put a canary inside of the mine to see if it died, right? To see if there were toxic gases before they had equipment to test, right? So the test equipment was the canary. They would put the canary inside of the mine. If the canary died, it's not safe, right? If the canary is still singing, well, then you can work, right? So that's why we call it a canary, the artifact in software development. So that document is my canary, okay? Then what I do, I use the system, the same system that does the check, but I use it as if I was the opposing counsel, as if I was Morgan Heibner, okay? So I configure the system, right, to basically look for how to attack the document. How would you take, from a legal point of view, could attack, and this is just a statistic analysis, right, on previous cases that have similar arguments, but using semantic analysis on each paragraph of the motion. If you can parse the document and understand the sequence of ideas, you can find legislation or precedents of issues described in these paragraphs, right? And then you can find what you could do to attack the document, right? So then with this, I created an iterative framework that allowed me to basically create a canary, test it. The mine would be a similar system, but configured to work for Morgan Heibner to see how she would attack the document. After I see how it's get attacked, then I go and change my document to protect it from that attack. I run it through my checks, and then I have a new canary, and I put that canary in the mine again. And I ask the system to attack the new canary. The system attacks it and tells me, this is the way to attack it. Then I go and improve the document. It's an iterative process, you see, just as in software development. And I have versions for these canaries and everything. So to give an idea, when I was working on this document yesterday, after 14 or 15 iterations, 15 canaries, I got to a point, and this is super interesting to me. It got to a point where it got stuck, in the sense that the two systems where, I mean, I'm seeing the conversation, I'm seeing the back and forth, right? The canaries, as I move them, and I'm seeing what's happening, and they're just stuck in the sense that they're stuck in a technical, dry conversation of legal. Let me give you the example so you see what it means, right? So I started, right, by creating my document, putting in the document my argument that the motion is in their motion is in bad faith. It's using the legal system as a weapon. And in fact, you can read the motion in the book. And here I'm gonna do something. I'm gonna present the book. Let me show you this. Okay. I have to tell you, the book, you can go to this website, diosdado.com, and sorry, you click on download, it will take you to this Google Drive folder. Sorry. In that folder, there's the folder for the audiobooks. You can download the audiobooks for free. And there's another folder for the PDFs. And the PDFs are in something like 28 languages at this point. And you can just pick any language and download. Well, so you have 3 volumes, right? The first volume is like more like locally here, local, hyper-local harassment, right? Volume 2 is more high-level geopolitical, a more geopolitical angle. And volume 3 is the counterintelligence journal that I sent to legislators and lawmakers around the world. So the one that it's in 20, not all of them are in that many languages. The one that it's more internationalized is the volume 2 because it's geopolitical. It affects the entire planet. Okay, I'm going to internationalize the other 2, but I have to prioritize because my time is, a resource that is constrained. So if you click on volume 2, you will see all the languages, right? And then you click on a language, and there will be a PDF inside of that language. And then you can open that PDF. The book is also available in Amazon. I've set the price to the lowest possible price Amazon would let me. But if you have a preference and you want to use your Kindle or whatever Amazon device, you can get the book also there. You can see it's just less than $1, right? Anyhow, so this is the so I'm showing you this not to do marketing on the book, which by the way people are reading. A lot more people are reading the book day by day. So in the appendix E, okay, this is the document that I was working on yesterday. It's already in the book. It's already in Amazon. So you can see my response there, right? So basically, I drafted this is not the first version. This is the last version. So this is Canary 14, I think. Okay, but to give an idea of what I did, I think the video is getting messed up again. Okay, so I drafted the document, right? And I said, I think their motion is in bad faith, and she already admitted that it's a litigation tactic and all that, right? And then I run the canary I run it through the system as if I was Morgan Heibner, right? Using the system. And the system tells me, well, the way you can attack this document is using the privacy rules of the mediation, basically alleging that that I'm going to stop the sharing of the screen because sorry, it makes the computer too slow. Okay. Yes. Okay. So yeah, so it says you can use something that is called the ADR, okay, which is it's one of the Texas confidentiality acts, and this particular act, right, and the things that the system identified that could be used to attack the document are about confidentiality in negotiations in mediation. Okay. So this is try to follow this sequence. It's a bit technical, but it's interesting. I mean, the interaction, right? So okay. So then I take the attack, right, and I modify the document. I do some research, and I modify the document, and I say something along the lines of, well, they are trying. So the argument for the second canary, right, is what I'm talking about. So the argument was something like, okay, they're trying to compel me, force me to go through an invasive medical procedure unwillingly, which is a heavy, invasion of my privacy in many respects and my own body. And they're also trying to censor my book, which has constitutional implications. And my argument was, well, the Texas privacy law cannot trump over the Constitution, right? So I raised the stakes to a constitutional issue. So I draft the document and I created a new canary. I ran the checks. The system, gave me suggestions. I improved my canary. I put the canary in the mine again. When I put the canary in the mine again, then the system tells me, well, you can attack it in this way. So there's certain specific clauses in that act in Texas, specifically Texas law, that say that this rule of privacy and confidentiality is absolute. That it can even trump anything. Like it's absolute, right? Then I made my responses stronger, by arguing. I run it through the system again to basically to attack their attack. So the idea is you get the attack from the other side and you run it through the system again, and you get recommendations on how to attack the attack. You incorporate those recommendations, and that gives you a new canary, right? So this went on for a few iterations, right? And at some point, the system tells me attack it by citing this precedent, because it has already been cited. This case has already been decided in a Texas court, and it's a precedent that can be used to justify, because when you cite a precedent like that, the judge enters into a dilemma, right? Like, if he rules like in the precedent, if he rules against what the precedent says, he would be contradicting the other judge, right, who is also a Texas judge. So judges are less likely to rule against something when there is a precedent that is very similar, right? So the precedent that the system found was a case of Alford v. Bryant, right, in Dallas, 2004. And in this case, Alford v. Bryant, the argument was that the rules, the privacy and confidentiality rules, were absolute, and the other party had raised constitutional or potential constitutional issues, and the ruling was that no, in Texas, we applied this before the Constitution. So basically, they were saying, the system thought that they would say in Texas we do it differently, right? And then they would cite this precedent. So that's a tough one, right? And then I take that and I put it into the system on the other side, like working for me, and the system goes into a more sophisticated argument, right? Like into a more it found other cases, and like this not exactly the same case, because so the next argument was in Alford v. Bryant, the argument was about what was being litigated. So it was a civil dispute, right? And the thing that was subject to litigation was the issue, right? But the argument that could be made on the other side, right? In my case, right? Working for me, the system working for me could be that, well, in this case, it's not the thing being litigated, because what I'm presenting, what they were, what their goal of the other parties, of Morgan Heitner, if they take this route on Monday, is to try to get the transcript out of the record, because the transcript is damning. Like, the petitioner is admitting that she's misusing the judicial system, right? The judiciary system. So the goal is to try to get it as inadmissible evidence, right? Because of privacy. Right? That's the goal. I should have started with that. Right? But the difference, right, is that in this Alford v. Bryan, the thing being litigated was the thing that would break the privacy rules. While if I run that attack against the system, in the system, right, as a canary on itself, the system would tell me, right, would pinpoint cases that suggest that the difference is that in this case, the thing that the exhibit is showing is not the thing being litigated. For example, this is supposedly a divorce case, right? So the relevance of this transcript for this case is not about who gets what or who gets the child. It's nothing, it has nothing to do with the divorce itself. What it has to do is with the misuse of the court to silence me and to weaponize it to harass me, right? That's what it has to do. So it's not, the transcript has nothing, is not being presented as evidence for the divorce. It's presented as evidence for the legal harassment, right? So it's a very, legally speaking, it's a very different concept, right? So I run it, I see that, I say, well, you know, with this, I'm gonna win it. So I draft it, right? Make the canary, and I put it to the system again. When I put it to the system again, the system configured as working for Morgan Heidner, you know, comes up with cases that suggest that you can, they're pushing for the thing that Texas, in Texas, this is an absolute rule, right? And, you know, I go through this iterative process a few more times, and I see that they're stuck. I mean, they're at this point trying to find both, you know, both versions of the system, trying to find more sophisticated, but at the end, the same arguments over and over again, right? So that's when I thought, you know, well, I need to intervene, right, to get them on a stock. So I look at the thing, right, and I think to myself, I think, well, I mean, thinking as the system working for me, right? What this system really should do, and I'm saying this because the system is not capable of doing this at this point. I haven't gotten to that level of sophistication yet, but I will get it there. It's not able to draw this conclusion on itself. So I had to help it, right, manually. But when I decided to intervene, right, when I saw that it was stuck in this loop, I thought, well, I mean, this is getting into a discussion of which rule trumps the other, right? To unstuck this cycle, the solution is to really bring it back to the question, right? To really, I mean, the difference in these precedents that both sides of the system were finding were not fundamentally about the same thing, because one was a pure civil case, right? But this is a family court. This is not about property, or, I mean, yes, it has implications on property, division of property, like it has those implications. But the one thing that this court is tasked with and cannot delegate or override is caring for the child. So the solution to break this argument is to bring this back to the child, right? To bring this back, not to the child, but to bring this back to the true purpose of this course, which they are perversing, right, and abusing. I mean, I mean the petitioner and Morgan Heidner. But the true purpose of this court is to see for the interest of the child, right? And if one parent is misusing the court and engaging in legally harassing behavior, I mean, harassing the other parent with the courts, that on itself is relevant to what is on the best interest of the child. I mean, if you have a parent that is breaking the law to harass the other parent that parent might not even be fit to parent that child. And that is something the court needs to address. So the court needs to look at these transcripts to make that determination. With that, they cannot throw it out. They can't, because they cannot change the purpose of the court. You see? So this is the leap. And this is what's fascinating to me as an engineer, right? That although the system is sophisticated and I put a lot of effort into this final leap, it could not do yet. It will do it, I promise you. I'll get it to that level. But it's not quite there yet. I had to intervene. But it's a fascinating work. I mean, this interaction. But on the deeper side of things, on the more philosophical, right? You see what I am doing, right? I'm using distributed computing to fight their lawyers. And this is not because, yes, I mean, I started on this path because I realized that I have to bring this to my court. I cannot fight on their terms because I don't have lawyers, right? But what I'm doing really, the bottom line, is that I'm using distributed computing to fight the legal attacks. And I'm successful. I can produce motions. I can shoot, like, I can refute the things that they do in minutes, right? It takes them longer to produce the bogus and, I would say even illegal motions than it takes me to disarm them, right, at this point. And this is because I'm using technology, right? It's through the use of technology, through the use, and specifically, of distributed computing, which is the nuclear weapon that they found in 1998, distributed computing, right? With the Hell app and all that, like that, it's that, right? And I think that the thought that I want to leave you with is that the only way to fight this network is through distributed computing. Not because they're using distributed computing, but because the nature of the attack is distributed. As a human, if they have 20 lawyers working against me, I cannot fight them, right? I can't. Unless I have 300 cores working on the problem. In that case, they can't fight me. So it's an interesting one. Similar thing happened with the SEC. So the Securities and Exchange Commission, I filed a whistleblower report almost a year ago. And they just replied to me recently, right? I hadn't had the chance to run it through the system because I've been working on other things. But there's a window of time in which I have to reply because otherwise I'll lose, right? Automatically. So the window was approaching and I decided to work on that yesterday, right? Too. And I did the same. I ran it through the system, did my iterations, and it's amazing. It works amazingly. Like, I mean, as a human, I wouldn't have seen this, right? But I saw it because I have a systematic way of seeing things, right? Now that I have the KOL legal vaccine, trademark pending. Now, what they gave me really with that denial, so this is what happened, right? So they sent me a preliminary denial. This is a letter in which they're recommending, so a person, the enforcement chief, Mr. Carr, is recommending to the SEC, he works for the SEC, and he's recommending to the SEC to not give me any awards for within the whistleblower program, and he states the reasons, right? And then he says something like, like the people that worked in this case that you're filing the claim for didn't even get your information. They didn't know who you are. That's what he said, right? In writing. He put this in writing, right? So I run it through my system, right? Of course, I have to say, the system has been augmented with the books. So the system knows everything that is in the books, obviously, right? That's the first thing that I did. Because now that I have all this structured knowledge in the book, I can fit it as a structured data input to on a structure that I input to the system, but with the parsers I can make it a structure, right? So for example, I know which entities are mentioned in the book, right? Anyhow, I run through the system, and the system immediately identifies the weakness. The statement on itself, the denial, is the weakness, because then this is a connection that is hard for a human to make, right? But what he's really saying in that letter is that the gatekeeper algorithm did work, which is the thesis of the book, that it doesn't matter who I report them to. I reported them to the IRS, to the DEA, to the SEC, to the police, doesn't matter who I report them to. The reports are never acted on because they have a systematic way of disabling the reports before they reach the actual person that would actually take an action, or that could take an action. So anyhow, the system recommends disarm it with this, but again, right, it didn't make the next leap. That I had to intervene, right? Because I was running the iterations and I saw that it was stuck, that it wouldn't take it further. I saw intuitively that there was more, right? That I could get it further as an action, but the iterations were not advancing. So again, I intervened, right? I said, my thought was, well, now that I'm requesting that you retract your recommendation for denial, I'm going to also take this opportunity to remind you that I'm in these books, and I added the books to the letter by reference, of course. In these books, I'm mentioning thousands of entities. And I'm formally requesting you, the SEC, the SEC, to look at the books, understand which are the entities, and cross-reference them with all your open investigations. And then the ones that match, add me as a whistleblower. So this flips the table, because now he has to do a lot of more work. He has to actually check the book. He has to read the book. Otherwise, he would be obstructing justice, right? If he doesn't read the book. And then when he reads the books and realizes that maybe, and I know this because I know that committing securities fraud is one of the industries of this network, right? That it's an industry on itself. So he's going to find hundreds of entities that overlap with the open investigations. And I know which they are, but I'm not going to tell him because I want him to read the books. He has to. It's his job, right? And then after he finds those hundreds of instances that I already know which they are, if he decides to not take action, he would be obstructing justice actively hundreds of times. So it would be hundreds of counts, right? So it raises the leverage considerably that authorities could have over this subsystem. Right? That's why I'm mentioning that. The stakes are higher now with that response, right? They could choose to ignore the response, to also deny it, right? But it's obstruction, right? Okay. Yeah, but I guess to end this session, the thought is that with technology, right, applying distributed computing is really the only way to defeat not only their distributed computing attacks, but also their human attacks. Because at the end, their human attacks are a distributed system. I mean, the workers are humans instead of servers, but it's a distributed system. And you can't fight that with people. You have to fight that with servers, with clusters of servers. Well, I think I'm going to stop it here, and I'm going to thank you again for your time, and till the next one.